Who is for the other side?
No, I am appearing for the back. So I have no objection. Let them.
Yes,
Managing Director,
got
OP
no
number 3. OP number 3.
That the counsel for the petitioner.
Yes, yes.
Say that, sir.
But my second matter, what I'm trying to tell you, Lordship, but all these matters are relating to cooperative society, managing director, suspension.
All are internal issues.
In fact, there is one second. There is a judicial order. All these matters to taken up with PIS. But besides that, let 2030024.
2030024.
Sub-item.
Give me the file.
Eat Prasad Rao Dora.
Yes.
Yes, yes. I think that is also good.
That is 20300.
Right.
Yes.
Probably which my understanding is saying.
Yes.
Is the matter.
For amendment, what is this?
Third amendment, we are trying to introduce the inquiry report forming basis of the disqualification order. Now, Lord, for the present, I am enjoying an interim order since Lord 22/8/24. That is an interim order on the issue of disqualification. Now, my client instructs me that he will go back to the register because natural justice point is involved and all the points are involved. He will go and approach the register, seek recall of this order. Only till that date the interim order to continue. Since otherwise, Lord, I'll have to place it on next.
You'll have to.
I'll have to place it on next.
You know the judgment of the Supreme Court says once the matter is finally disposed of, the interim protection should not continue beyond that life.
So in that case, I'll place it on merit.
You have to.
Take it up
You have to. Yes. You have to.
This is a single judgment.
No, he says that there is an order of the division bench that all these writ petitions will be tagged along with, if I correctly understand.
That has been filed.
That is there.
So there is no difficulty on the part of the division bench to take up a single bench matter. There is no problem by virtue of the there is no difficulty.
But in fact, your lordship, pass order.
I think
that is also.
Additional order also.
Let us not join issue there. But so we take up the matter some other day. That will do it.
Sir, we are sitting. Two division benches are structured.
One suggestion.
I will be left with no work because the next bench is.
That will be there. The lordship may take it up on some other day on merits. Today, in fact, I have some.
No count.
It's a disqualification matter, very important matter.
They have not filed the counter affidavit.
And no prior notice has been given. Inquiry report was never communicated to me. All the points are there. I'll urge it on merits. So, your lordship.
Then what to do? Both of us.
Then I may miss the opportunity to hear you.
My lords have not many breakthroughs today.
Yeah,
so my lords will be engaged in.
No.
But I will be deprived from this opportunity of this bench. Not so frequent.
Maybe at that time Monday also.
The difficulty is because both the division benches have to be
countering also not
disrupted.
In one case, this case counter has been filed.
But in that case, I can ask you.
Not the
state action. State has to file the counter affidavit.
state has
If the state chooses not to file a counter affidavit, can we compel or you compel them to file?
In fact, they have taken time for
Whatever they chose not to file. What is there?
Normally, your lordship passes that order. If I am allowed to go there, seek recall of this order. with that little protection for 15 days or 1 week. But that is continuing for since 2020.
That's
And your lordship is not
wrong practice.
no, your lordship is not relegating me on the ground of alternate jurisdiction. But Runta, LG Runta will not come into play.
No, I am not talking about.
Your lordship, please, I don't mind that. I don't want to bind your lordship anywhere. But then I suggest it only. If I can be relegated there for 1 week time with this interim order, it will solve the problem. It will entirely solve the problem. So will be over.
If all of you agree, that
Yes, agree, my lord. They all agree. State will agree. State will agree, my lord, because lordship has recorded on last occasion that it is settled at the
Unnecessary.
all agrees, appearing parties. No.
Kindly see order dated 17/4/26 in PIL 34933 also in this matter. Kindly see 34903. Your lordship has recorded that there is an amicable resolution of the dispute. State will agree. State, we have surrendered to the state. I don't think state will object to this. Because we want to go to them also.
Who is the contesting parties here?
Contesting party will be the state.
And
And bank of course.
Bank
And
directors
the chairman.
So-
Chairman of the bank. If
are they
object to
agreeing for that let it go back?
Sir, let it go back.
Not the problem. Taking the
Interim order. That
action there, the issue, because that will be presumed as
No,
if it
no.
has been given a blanket ballot.
There is already an
coverage.
interim order operating.
Since 2020.
No, that is why we filed the intervention. Also, the application for petition of stay is also there. The state, if it chooses not to, because of the compromise, not to file the counter affidavit, we cannot also force them.
I think register and state, I don't mind. If they object to it, then I'll have to register.
May I suggest me one thing? Let this matter be go to the register, then the matter to be disposed of by the register within a fixed period. So that till that
Yes.
date, there is no
till that
restriction.
To that extent, we have so.
Interim
till
order-
that date. Till that date.
Yes, yes.
My lord is asking whether
Yes.
till that date.
Till that date.
Will you agree?
Fix up a date, yes.
Mr. Swami,
It's a
what
fix
is
of
your,
short date.
Mr. Swami, what is your submission on the continuance of the interim order? If you
Well-
agree, then on agreement we can only pass the
No,
order.
the interim order
Make
continue
disposed of
to
matter,
the
we
date
cannot
when to be
continue.
disposed of.
He agreed. He agreed.
You also fix up a date within which matter can be disposed of by the register.
Also
Till
there.
that date. to continue.
What about interim order?
What
Till
about
that.
Interim production, that is the only thing.
Sir,
Till that date.
Sir, I agree.
So I agree.
But there are other parties.
Nobody else is there. They are
Mr. Ratha,
Filing intervention petitions.
Or they kindly consider.
Mr. Ratha, the problem is he is not
Let them
speaking,
go there.
he is not submitting it clearly.
Say disqualification of a chairman matter.
Leave it to Mr. Swai. Because Mr. Swai says
But others what say they can have with regard to disqualification of a chairman, it's a personal cause of action between the state and chairman. There are no way parties there when the order was passed by the chairman.
Disqualification came at whose behest?
It is only a show order proceeding. No, at behest of nobody else. It's a show order proceeding.
And malfeasance and all allegations,
No.
everything are there.
That is-
We have got on record.
So we can permit you to be heard by the
And
registrar.
person citizens itself.
If it is there, any person who is interested,
Let them-
he will also be heard.
Yes,
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 But,
Till the date
but
your lordship, what I propose, subject to what my friend said also, Mr. Rai, till the date of filing or the first date of being taken up, then the continuance may be left open to the registrar if he wants to continue with the.
what is the interim order which is passed?
The disqualification.
Disqualification has been stayed.
So who is continuing?
But I am
It
continuing.
is continuing.
I am
You wanted to be placed there.
No.
Then?
We are the board of directors who are, the allegations are against him, where we have given
Okay.
the materials of malfeasance and the cycle of the funds, the funds being diverted to other accounts, everything we have given. So we are interested in that only.
In a personal account. Money is diverted.
Not personal account, but
But
through,
he has.
as you know, since, let me
No,
tell what shell
check it.
companies and since shell individuals.
But he has taken on foreign too. That is one allegation. But kindly similar. That is inquiry report per se without jurisdiction. I take those.
Foreign tour funded by
But
cooperative.
no, not cooperative. Official too. Official too.
That means the funded by the cooperative.
Yes, official too. All on file.
Sir,
Which
my
of the
problem,
countries you traveled?
sir, my problem is the entire bank has now become complete standstill because of the interim. Yes.
Once I go back, things will
So,
go over.
whatever it may be, the interim orders should go. That's
No,
why
no,
that.
it was continued till that day. But otherwise, there is no point in sending me back. I'll be out.
You are appearing for whom?
Bank. Managing Director, OP number 3.
Okay.
The allegation is against the president, but they have superseded, suspended all the members of the managing committee. There is no allegation against the members of the managing committee.
This is not.
We are appealing for the managing committee members.
Who has superseded?
They have suspended. Sorry,
Who?
the registrar. There is no allegation against
So
the.
you don't have confidence on the registrar?
The problem here is again,
Joint
MD and
and
register,
Joint and
one second, Mr. Sama. MD and register are same.
MD?
MD of the bank and registered the adjudicating
Sir,
authority.
exactly. That is not. That what has happened.
That is one of the matter.
What?
That is the
What's the allegation?
Sir, the
That's the
problem
main
is.
allegation.
Sir, because
That's
Mr.
an allegation we have.
Sir, the problem is.
Oh, Mr. Doloi is also there.
Then send us back, Milord, that will end the problem. Send us back, Milord. Only that much I make a prayer. Instead of joining issues with so many, let the register answer.
Practically, I am appearing for the register because the managing director, register is in charge of the managing director.
That is the whole issue, Lordship.
There is a comment of praise
Register.
that this will not regular page on many occasions, so it should end on a happy note at least. So let it go, let all
Yes, sir.
present
You
there
also,
That will
till
tell.
filing, then let it
You
go
also
on the
fix-
register if he decides.
you also fix up a time limit. You also fix up a time limit within that time.
There is a. So Nando has a rider.
Achha.
So Nando's rider is that I don't mind sending him back to the registrar. Till he approaches the registrar by making an application, I have no issues. But the moment the application is made, then no continuance of the
Yes, sir.
interim
Yes,
order.
yes. That is also.
But it
Register
should be
registration.
registrar to decide.
Register has its own discretion.
Let him use his own discretion and
Back, my humble submission would be, I'll make a prayer to the register to that effect.
Yes.
Please consider.
Yes.
That will be it.
That will be registered.
Yes, yes.
Authority having power to pass the final order has the power to pass the Supreme Court. That's it.
67.
67.
Mr. Rao.
Income tax matter.
Income tax matter.
That
I think that would assuage everybody.
But
Yes.
in respect of the members, but in respect of the
But
members
Mr.
of the managing
Samal
committee,
is not there.
you have my heart.
This is the other matter you are
Order
here.
of suspension.
He is not agreeing.
No, he is
There are
different matter,
allegations
not in
against
this
the
matter.
president.
He's a foreigner.
He is
I am
in a
member.
different matter, not in this matter.
Member.
No,
See,
not
the
in
matter
that
you can find the
collected.
He is not here. Why the
Sir, I am talking about.
Then I'm talking about the rest of the matter. What is the matter?
This writ petition by
He is not there.
I have
Oh,
no
it's just right. I was just under the impression, I think my brother will also have the impression that all these connected matters will go back to
Yes,
that.
yes,
To it.
let's all go.
But
I agree. I agree.
Yes.
but not in isolation that one matter will go and
No, all the matters.
All the.
That was all the problem.
individual grievances.
No, no,
Yes.
Members have
Except this PI. Except
Yes,
this PI.
just imagine.
All the matters let go.
You expect.
Mr.
Sir,
Doloi is in PIL.
Except this
So far the PIL is concerned, unfortunately the council was appearing, the sole council, he has expired.
No. That is by
See,
PIL is first.
PIL is Mr. Doloi.
Shakti Datta Tripathi.
No, I am first case. First case. That is.
That your lordship may decide it.
In that case, I not standing.
What is a PIL?
PIL lordship, a personal lordship is holding the dual charges lordship. That is the whole subject matter. That is not permissible under any lordship.
सही पे entry order नहीं,
Okay.
सही तो नहीं problem.
A person cannot assume the dual charge.
Dual charge lordship. He is the register lordship. He is the managing director, chief executive official lordship. All the lordship. It has to be independent lordship. A person cannot be judge of his own
That is
subject. How
because
can he decide,
that is
Lordship?
because of the
Lordship, kindly see now, Lordship is relegated to the matter of register. He is the managing director. He will issue.
If-
He will decide his own case, Lordship, own cause of action.
He will be acting in a different capacity.
But Lordship, a person, same person, Lordship.
That was the issue.
No, no.
Let me approach.
yes.
I am from the instruction.
If your lordship will look
Let me
to
approach under what circumstances register was put in charge. Let me approach. There is a judgment. Venumadam Tripathi passed by this honorable court versus State of Orissa. That was a writ of quo warranto allowed by this honorable court, wherein he then managing director was removed by issuance of a writ of quo warranto. On his removal, who will manage the bank? The question arose before your lordship, and the honorable bench, as their lordships were there, they passed an order that the register shall remain in. There was an interim order.
That's
Register
an in charge,
in charge.
passed an order to remain in charge.
not holding a substantive post.
No.
But that petition, after it is disposed of, the interim order stands merged with the final order. It's no more available. But the register from that still continues.
Still continuing,
That is it. He is raising that.
Lordship.
But the final order which was passed, still that is sub judice, that has not been finalized. In fact, I have given the opinion, unless the court permits it, who is the register? Register has to
In
be
fact,
remain in charge.
bylaw is
That is
there.
the problem.
42 of this bank bylaw says the committee of management can put any officer below MD in charge of the management. Rule 42 of the bylaw is there.
Sir, in fact, there is no managing committee because of this interim order and this. Yes,
Suspension of
there is
all
no
the
managing committee.
banking
That is why the bank has
Now,
now the
Lordship,
great
That's a-
RBI has clarified, Lordship.
Suspension rather
That's a catch-22 situation.
Lordship, now on 15/6, Lordship, RBI has clarified the entire issue. Lordship, kindly see.
Anyway, that's not a question now. It is
No, maybe, but Lordship, that is the
government.
now RBI has clarified, Lordship. A person cannot be in dual charge. Lordship.
no, it's a register will be out. That is the best thing.
No, I don't have any objection.
The register who was there, he has already been transferred, already retired. The successful experts have come. The best
No,
course
no,
would be okay.
what the RBI circular says,
Yes.
a person may be put in charge, but it should not be perennial or to continue
Yes,
for a
but
longer
Lordship-
period. Immediately you take a step so that you can appoint an experienced
Lordship.
for a period of 3 years.
like a stop.
So it is not really, it's a stopgap measure actually.
But they
It is very
But it
difficult.
should not continue
Continuous,
indefinitely
Lordship.
for
And it is very difficult on the part of the register to discharge the duty of the managing director also. A great difficulty will have. That is my instructions.
In fact,
He wants to be relieved.
there
And
is a-
bank must allow to be function. Bank is not practically, the financial part is already, interim order has been passed. That no, only day-to-day expenditure is to be made. Even laws have not been paid, then speech also. Mr. Manasi is appearing there.
the civil judgment will not
Online.
Mr. Nanda is appearing along with me in some cases.
regard to appointment of managing director. Also, there is one more factor. If the committee of management only is authorized to appoint a managing director following the fit and proper criteria issued by Reserve Bank of India or NABARD. There is a fit and proper criteria to appoint a managing director. There is also a judgment passed by the honorable single judge
Just I'm handing over.
directing the committee of management to immediately take steps for appointment of the managing director.
Man,
But now the managing committee is
Not
suspended.
yet, sir.
Now the
That's
What to do? That is what I'm saying. Then who will appoint?
So you also leave it to the register, let him take a decision. That will be.
That has been protected by your lordship. Stay order has been granted for the suspension of the managing committee members. They are continuing. And
No,
there is
no,
a- there is a provision under section
But
30.
with the limited authority, if he's saying that with the limited authority, not a full-fledged authority of the.
I also in conflict with this honorable direction. They cannot also override those.
And there is a
No, the
special-
difficulty is if that direction is there, then how the registrar will function.
That's right.
Then again, he will be grappling in between these orders of the court.
Exactly.
So then in that
That is
event,
exactly
it's
happening,
better to
yes.
decide in the court.
There is a
I think
provision
it is
under
better to
section
decide in the
30
court. What are the entitlement eligibility criteria so far as the MD is concerned? That can be done.
No, to that extent, your lordship.
So where is the difficulty? Not necessarily relevant.
Lordship need not go
But
to
the only thing is, what?
Lordship, leave it to the register, let the register take a decision on this, so that at
He
least.
will be then encircling around the orders of this court.
No,
the
no,
court's
your
order-
Lordship is already vacating the interim order, so
Where
far
the-
that register will be in charge of the
But
managing
Mr.
director.
Nando is
Kindly see.
saying that there is earlier order.
By virtue of that was that interim which continued later on by the
confusion
passed by my notes. But there is an interim order directing suspension, stay of suspension with a rider that committee of management will not take any decision for offender.
That is what I am saying. That is what the conflict is. So,
The situation
so if all these orders go through the managing committee will also function. But then again, their qualification or disqualification will have to be decided by the registrar. Again, it has.
That effect, there is a provision under section 32(7). The order of suspension cannot go beyond 1 year. And there is constitutional provision also, 243 ZL. Suspension cannot be for a period more than
that period has to again
1 year.
I am not opposing, but as an officer of the court, I have a duty to address your lordship on this. That suspension order has been stayed all through. How can that 1 year period be done?
Even if the registrar has not filed an application for vacation of stay.
No, if the order is suspended or stayed, then there is no order in the eye of law. Only thing is, it is on paper, but it is not in effect.
Correct.
Operative.
1 year.
My lord, they neither they
That's
filed
the
a
whole
counter
problem.
affidavit nor they seek for a variation of the order.
But the power is not.
No, that is what I'm saying. That it will be on paper. His existence is there unless quashed and set aside.
Yes.
But at least its operation is suspended. So it is really in limbo.
There is in fact absolutely no allegation against the member.
I understand that is if the registrar decides. Registrar has superseded. The registrar has superseded the committee.
Yes,
The
yes.
registrar has a power to again left
Also that
whatever.
the entire thing will left to the registrar. That will be better.
In fact, the first two matters,
No, all,
All.
We have known.
including
All
PIS.
Yes.
including PIL, all.
Let everything go.
Except my matter, Lord.
No, yes, including PIS.
Yes.
That's the apprehension.
In his case,
No, everything will go.
registrar will be deciding whether he will continue or not. That is in his case.
Let it
Can
be
you
there,
not-
let it be there, Lord.
Can you not
They will
anticipate
decide and
that?
they will
Yes, can fine. Yes.
There are two. I am telling you, there are two. I think the thought process in this regard. Under the common law principles, what he is agitating, a person cannot be judge of his own cause. But there is also an exception which is attached to it. And there are, at least I could lay hand to 3 judgments, which says that there is no difficulty. If they are discharging their duties in their respective official capacities, then in that event, these principles of judging his own cause will not stand in the way.
Yes.
Because it's a what the different powers which he has, and he is exercising that. So it all depends upon the facts of the case, what to do and what not to do.
Exactly.
So
And he will
that is
accept-
what I was just thinking
Yes.
in that line. It's not a broad principles in that sense that
The state power as delegated by the Honorable Court. Let him decide whether he should continue or not continue.
Lordship, right?
And the writ application which has not been placed by Mr. Rath, that also stands. That's all.
That is gone.
so it has received a natural death.
Kautra has not allowed me to exist. He has finished me.
So why you are bothering about that writ petition?
Yes.
It has received a natural death.
I was
Not a minute.
under the impression again you are saying.
Giving you the 3 weeks time to decide it, or 4
Yes,
weeks
yes.
time maximum. Maximum 4 weeks time to decide. And you will afford an opportunity of hearing to all the persons interested therein.
Yeah, okay, they fix a problem.
No,
Can
you
you
will
fix
say
some
that
date?
all the persons who are representing in these matters before this court, not outside.
Can you achieve with the consent of-
Fix up a date.
With consent of all, we say
Yes.
including the prospective intervener,
Yes.
will say so.
Those were
Because his application has not been allowed. So we'll say the prospective intervener.
Yes.
maybe all of them are after a particular
Yes,
date.
that is what I'm saying.
There are 2 timelines, one for the approaching him.
No.
No,
What I'm
Yes,
saying,
yes, you are
So
correct.
that, my lord,
Yes, this is more reasonable. We'll put two timelines. One is that within this time he has to approach.
Yes. On that
Yes.
day, it will be.
And the second timeline for disposal.
Yes, yes, yes.
Exactly. That was
As agreed by all the parties.
Till that day, till that day.
It will continue till filing of the.
Yes, yes, yes.
Till the filing.
On the very date it can be also. On the very date.
And the liberty
first year.
will also give you the liberty to renew the prayer for an interim order before the registrar.
Same disposal.
Yes. And the registrar will decide it independent of the fact that this one has been
Without being influenced
by using
Since
his
your
own
lordship is
independent.
fixing 4 weeks time, and since your lordship is fixing 4 weeks time,
Yes.
since
Happy for one reason. The PIL has also.
disposal.
without being influenced by any interim order. That's why I record it without being influenced by any.
Mr. Raut, what I said, independent,
Yes, sir.
being not swayed by the fact there is an interim order. What more? My language is very bad.
No,
Not in the same way.
Very clear.
very clear. Okay.
Very clear.
And we also come the high praises for Mr. Dara, as your lordship's expressed.
Yes. So all disposed of.
Great, what we talk in this amount of files.
Next.
Got two. Item number 2, my lord. Even the disposal of writ application, my lord. Lord, if I directed.
Sorry,
I'm sorry.
Can you repeat?
Yes, in this disposal of writ application, this honorable court had directed that my application for renewal for proposal for an alternative mining site shall be considered by the authorized officer. Now, in the I had filed this contempt alleging non-compliance. In the meantime, my lord, he has rejected the claim. We have filed a writ application.
Okay. So it has become infructuous in that sense.
Yes, sir. In view of filing.
Where? The original writ.
May I please, Lordship?
What?
Lordship, kindly permit to withdraw.
On what ground review?
Lordship, kindly permit to withdraw this matter because the Lordship, the writ appeal from which this review which arises has been conducted by another council, Lordship.
Oh.
Withdraw.
Yes, Lordship.
Withdraw.
Oh, bless.
Contest addition item number 1.
May I please your lordship.
That matter.
May I please your lordship. Your lordship, on the last occasion, your lordship has raised query that on which part of the order dated 11/8/2023 I am seeking review, your lordship. Paragraph 6.2, your lordship, of the order. The period of suspension may be treated as non, but without breaking service, your lordship. I have submitted, your lordship, that in that suspension period, I have attended the
Where?
office, your lordship. Your lordship, that is written paragraph 2, your lordship, of additional affidavit dated 24/7/2023 to the read application, your lordship, 23780 of 2022, your lordship. That it may be some may please, your lordship. May please, your lordship.
Yes, last occasion you showed us, we went through it. Where is the averment?
Your lordship,
Where is the averment in your additional affidavit?
there is no specific abatement, but under Annexure 6, Annexure 11, your lordship, page 6, your lordship, they have stated that you have been placed under suspension with effect from 11/9/2017, but that during the headquarters at Jaipur, the first well, you are remained absent from the headquarters without obtaining permission on 6/9/16/17/23 April of 2018. your lordship.
So what is the difficulty? If the court has said that it will be absence will be treated as dies
Yes, your lordship.
but without any break on service, then what more?
So, your lordship, we have been
That cannot be an error apparent on the face of the record, sir. You are trying to just re-argue the matter. You're trying to re-argue the matter.
that is
This cannot be done. This is not a
that only point, your lordship.
no. There is a positive finding of the fact-finding authority that you were unauthorizedly absent. This finding has not been interfered with. Only modification is that continuity is ensured so that at least pensionary benefits is not really hampered in that.
But it is a fact that
It will not be continue as a break. So that is
the charges has already been exonerated for
no, whatever is there, you can't. You are not entitled to any financial benefits for that.
have been
No,
attending,
no, sir.
your
No.
lordship, for the suspension period.
Sister, that it cannot. Only points?
Yes,
That's
your
all. Thank you. Will you write? Huh? Yes. 2 pages. 2 pages.
lordship.
Item number 2.
Item 2, my lord, order compliant. Order compliant, my lord.
I have also filed affidavit to
They
that.
do not want. It is submitted by the counsel for the petition.
Item number 3, my lord. My lords, here,
This is the order of 4-9.
4/9/2024, my lords.
There is delay of 507 days.
My lords, I have sufficient explanation for the delay, my lords. My lords, may kindly see the order
Sir,
that is under review.
sir,
My lords.
what is the ground for review?
My lords,
Let
the-
us see. You
My-
have given a consent. They said that the instant writ petition has become infructuous.
my lords.
You did not dispute.
My lords, actually,
Then
the
in that event, the court has said that yes, dismissed as
My lord.
infructuous. What more?
that I have explained in the review petition, my lords.
Yeah, what you have explained? What you have explained in the review petition?
My lords, actually, what
What is his
had
name?
happened was, my lords, on the date, the conducting counsel was absent due to some personal difficulties, my lords.
I'm Mr. B.
That day, the order was passed, my lords.
Oh.
No, my lords.
So you are a third counsel. So can it lie?
My lords, but I have explained
AIR 1997 Supreme Court 1005.
a substantial issue.
I am asking you, sir, have you seen the judgment of the Supreme Court?
My lords, I'll have to go through it.
No, go through it. Give it. One paragraph. Right hand side page, one paragraph. Read.
Because in this case, you are disputing that what had happened on that day. So unless, exactly. So unless it is the same
Point
counsel,
was also not present. This is not an affidavit coming from Mr. S. Mr. So, how do we believe?
My lords.
You are really raising a question on the integrity of the advocate who was appearing on that day, who says, yes, I have no dispute to the proposition.
No, actually, what had
And if I accept it, will it not put a stigma on his part, on his role or a conduct? How can we?
why don't you ask him to come?
My lords, I will.
No, okay. This is what I'm saying.
This is the problem.
Yes.
My lords.
And also bring that AIR 1982 Supreme Court, page 1253 or 14 something. State of Maharashtra versus Ramdas Srinivas Naik.
That's subject to your lordship's approval. May I propose one thing, my lords? I'll request the conducting counsel as on that date, my lords, Mr. S. Mishra,
That
to
is
file an affidavit.
We are not here to adjourn this matter. The bench is a broken bench.
I understand.
You should know the law. You should understand before you file a petition. You can't do it in this fashion, so casual.
I apologize.
Can you find out that 82 Supreme Court? I think the second volume will be there after 1000 pages. Yeah, 1982 Supreme Court. Second volume, I think 112 something or 14 something, whatever.
1249.
1249, no?
1982, 1249. Have you gone through those decisions of Tungabhadra and this decision?
As Tungabhadra, I've gone through, my lord.
Tungabhadra is 1968 Supreme Court, I
My-
believe. That is on a different
My
note.
lords.
Here, these two decisions stands on a different footing.
My
So far as the 97 is concerned, the Supreme Court in that judgment has deprecated the review application to be filed by another counsel who did not argue the main matter.
My lords.
That is a 1997 Supreme Court. 82 Supreme Court says that you cannot dispute what is recorded in the order.
My lords.
It says that the recording of the event in the court is sacrosanct. Nobody can dispute it.
My lords.
Well, sister, this is what. Look at the language of the very first. That's why I say right hand side page. That's a wonderful judgment. Starting of the language. It is a sad. What it says.
It is a sad spectacle, my lords.
Read.
I may
Read.
It is a sad spectacle that new practice unbecoming of worthy and conducive to the profession is cropping up. Mr. Maria Utham, AOR, has filed Wakalattama for the petitioner respondent when the special leave petition was filed. After the matter was disposed of, Mr. V. Balachandran, advocate, had filed a petition for review. That was
Another advocate.
My lords. Bow down. That was also dismissed by this court on April 24, 1996. Yet another advocate, Mr. S.U.K. Sugar, has now been engaged to file the present application styled as an application for clarification on the specious plea that the order is not clear and unambiguous. When an appeal special leave petition is dismissed, except in rare cases where error of law or fact is apparent on the record, no review can be filed, that too by the advocate on record who neither appeared nor was party in the main case. So I abide about it.
So, you were neither the arguing counsel of the matter. Can you file a review application? I'm asking. We are bound by the judgment of the Supreme. So, how can it be? And look at this judgment. The right hand side did not. Right hand side, middle head note. Right hand side, color. Middle, yes. Middle, the paragraph. What it says.
The court is bound to accept the statement of the judges recorded in their judgment as to what transpired in court. It cannot allow the statement of the judges to be contradicted by a statement at the bar.
If the court has recorded the event, what happened, that he has not disputed, can you contradict?
My lords, I bow down, my lords. These are binding
These are the
decisions of the Supreme Court.
staring at your face, sir. What to do? Not maintainable in both the courts.
My lords, the only hindrance will be that I will be left remedilized.
I do not know. I do not know.
My lords, because after the passing of...
What we have done, then we have to defy the mandate of the Supreme Court.
My lords. But subject to your lordship's approval, my lords, I'll get a affidavit sworn before the
I do not know.
Court Commissioner, my
If not,
lords.
then this 97 will be staring at your face.
My lords.
What to do? In both the situations, I have said, if you contradict that it has been wrongly recorded, then also 82 comes against you. You have already filed a review. You were not an arguing counsel. 97 comes.
My lords.
In both the situations, what to do, sir? Can we go ignore the Supreme Court judgment?
Absolutely.
We are bound, you are bound, everybody is bound. Nothing.
My lords, may then kindly, I request your lordships, my lords, may kindly give me liberty to file this review afresh, bringing the advocate on record who was at that point.
That we cannot give.
But otherwise, I'll be left remediless because, my lords, after that point of time, we filed a fresh writ petition bringing the same issues before the Honorable Court, my lords. My lords, we've also filed an IA for recall, my lords.
Oh.
Ultimately, we have come up before this Honorable Court in review, my lords.
Oh.
And the substantive question of, my lords, still remains to be decided, my lords. In the order dated 4/9/24, my lords, that para 4, the Honorable Court gave us liberty to approach the appropriate forum if the cause of action still subsists, my lord.
You went, you withdrew. Why?
My lords,
you went and you withdrew. This was again your conscious decision. Now you will say that the senior counsel who withdrew was not really competent. And the second writ petition was filed by the same counsel who appeared.
My lords.
Am I correct?
My lords.
There it is a short name, but in the next matter it is a full name.
My lords.
So now you have come and contradict. What happened to the second one?
If your lordship allows me, my lords, I was present at the time the second writ petition was filed, my
Your
lords.
name is not reflected anywhere, sir.
My lords.
The name of the senior advocate and assisted by some advocate means who argues the first matter.
My lords.
So,
but I had filed my power in that case, my lords. I was also.
I cannot, your name, you may have filed, but you were not present.
My lords.
An appropriate forum, when the court granted you liberty to approach the appropriate forum,
my lords,
did it mean the High Court? If you were there on that day, so did the court say you filed a review? I mean,
no,
was that the intention? It says appropriate forum.
My lords, only the.
What you have done, a further blunder which I can see at page 16.
1/6, my lords.
Yes.
We filed an IA for recall, my lords.
What? Then? Because my sister has read, I have not read. She said that you have said that that gentleman who appeared on that day, when that petition was dismissed as infructuous, actually he is not an arguing counsel nor he is an advocate at record.
My lords.
if that being the position that he was simply interested to engage, take an adjournment,
My lords.
then what is the proper remedy? Proper remedy was page 16.
My lords.
Withdraw.
My lords, if your lordship allows me, my lords, in
Again, after withdrawal.
in both the occasions, my lords, the subsequent writ as well as the IA for recall, my lords, the learned senior moved the matter, my lords, and what transpired from the discussions, my lord, was that the proper forum to, my lords, ventilate this, challenge this order would be in
Are you
review, my
sure?
lords.
Are you sure? You have to take a conscious decision. Review lies only on 3 grounds. None of the grounds you have taken comes within the purview of the review. It is neither error apparent on the face of the record. It is neither a discovery of new and important document, which despite due diligence was not within your knowledge, or for any substantial reasons. Nothing. Recall, you withdraw. What more? I can't help you out.
And Mr. Mishra,
Yes.
till today I have not seen Mr. Naik. Mr. Chinmay Kumar Naik,
My lords.
who's the counsel in the writ petition,
My lords.
till today I have not seen him. Because most of the time either you are arguing or Mr. Kanungo is arguing. This is a fit case where he should come.
As your lordship pleases, my lords. If
The
that,
lordship does not please. It is your case, you have to take the call.
Sorry, we can't help you out, sir.
Niles may kindly give me liberty to file an appropriate application, my lords, for
Again,
recall of that
what?
order, my lords.
Now I am asking that what would be the appropriate relief?
As is fallen from your lordship, my lords, an appropriate application would be an IA for recall, my lords.
You have already withdrawn.
My lords.
Can you? I'm asking. Granting a liberty which has no meaning, can you do it?
When you were granted liberty to approach the appropriate forum,
My lords.
instead of approaching the appropriate forum, you file another writ petition.
My lords.
So was that the appropriate forum?
No, even IA, which he
Thereafter,
correctly done,
then he came with
he
the
also withdrew.
withdrew.
What more? No problem. We should not. Yes, what to do, sir? Tell me.
Yeah, I may be permitted to file the application for recall afresh, my lords.
Will it yield any purpose?
That's because my humble submission before your lordship is, my lords, the substantial question remains to be decided, my lords. The opposite parties have
So
wrongfully.
even if the law creates an embargo, law creates a hurdle, still you can. There is no difficulty.
No, my lords. That is
Because
definitely
it
not
has
the
to be
case.
substantially hard.
My lords.
That's your understanding. We can't help you out. It is your understanding, sir. Yes. No, we are going to discuss.
My lords, in that case, I'm yearning for your lordship's guidance, my lords, in the matter, my lords, because
What? What I can do? We'll go by a law.
yes.
Can we go beyond the law?
What do you want, Mr. Mishra? Other counsel are waiting.
Let us dictate and do it.
May kindly give me some time, my lords, I'll examine this issue, my lords, and
Sir, once a court put a question to you, it is really very, may I again use the word sordid state of affairs that
my lords.
it encourages only the adjournments. What is the role of a lawyer when he is conducting a case? Yes.
My lords, may kindly allow me some time, I'll
What?
examine the issue thoroughly, my lords,
Nothing.
and as to what happens to be the actual appropriate forum, my lords, for ventilating the events.
There.
My lords. My lords.
How many days delay?
My lords, delay as pointed out by the registry is 507 days, my lords.
So
My lords,
you were pursuing the remedy, that's why.
my lords.
What?
My lords, we filed the writ and then the IA for recall, and ultimately, my lords, we filed the review.
So
That is well. Yeah.
So what do you have said about it?
My lords.
Huh?
I have explained the delay in my IA for condonation, my lords. IA number 149 by 2026, if your lordship sees, my lords.
What?
149 by 2026, my lords.
Paragraph 2, what have you stated? Fault of the council. I think this is the fault of the council. Unfortunate. Had nobody been there, it is a different matter. Somebody was there, you are saying came to his knowledge after 2 years or 1 year.
No, my lords, the order was passed in 4/9/2024 in the WPC 18041 of 23, my lords. Thereafter, my lords, February we came to know, my lords, and immediately thereafter.
What do you mean you came to know? Council was there.
My council
Had
was
it
there.
been none appears dismissed, I can understand. What is this explanation that came to know?
My lords, immediately thereafter, my lords, we filed the writ petition, my lords. The writ petition was filed on, my lords, 11/3/2025, my lords.
No, we are dismissing it.
That's my dismiss it. My lords, may kindly just give me liberty to.
What liberty?
He is actually currently outside the Odisha, my lords, for a surgery.
Yes, it has withdrawn that I.
My lords.
Withdrawn that I.
But in the subsequent writ, my senior Mr. Kanungo was present, as well as the IA for recall, my lords. Along with him, I was also present in the courtroom, my lords.
That's your argument.
I may be pardoned, my lords.
That's your only the submission argument, no pleading. Anyhow, we are believing that.
I'm grateful.
But still, your name is not reflected.
My lords.
When there is a conflict between the oral statement and the documentary statement, which should prevail?
My lords, subject to your lordship's approval, my lords, the subsequent writ, which is a disposed of writ, my lords, maybe that record may be called for along with this, my lords. It will be clear, my lords.
What will be clear, Mr. Mishra? That order is already there.
But with regards to my power in the case.
No, that's power, but a person may have a power, but it did not appear. So
I'll file an affidavit if
what affidavit?
the lordship directs.
This is not a case which is coming under the purview of the. No, sir, you can't. Though there is a substantial delay.
On the next date.
My lords.
For your.
He was supposed to come today, my lords. Actually, he had to.
No, supposed to, but you have not mentioned that supposed to. That we are assuming.
My sister has come to your rescue.
I'm deeply obliged.
Give her time.
Next month ଗୋଟେ date ଅଛି ନା? କୋଉଦିନ ଗୋଟେ ଅଛି last week ରେ ଆମେ ଯୋଉଦିନ date ଥିବ ଦେଇଦେବା.
Give next.
Item number 4.
My lords is posting it to
18th September.
18th. I'm deeply obliged.
May I please, my lord, kindly have the last 14th August order.
Yes, where is the writ petition?
Writ petition. Please.
Petition.
27130.
Achi record ta achi.
No. The order is passed in which writ petition?
He is seeking review of the writ appeal.
Review?
Writ appeal order. Writ appeal probably not stated.
Rate number I had given 27130 of 2017.
Which writ petition? That order.
The writ appeal. Writ appeal 27130. That was a common order.
No. Common order. But that was a writ petition filed.
I am simply asking a very simple question.
Yes, Madam.
The order passed by the single bench was assailed in WA.
Yes.
Writ appeal. Which was the writ petition and what is the date of the order?
That is 27130 of 2017.
That is the writ petition in which the order was passed, which was challenged in the writ appeal. Now you wanted a review of the order of writ appeal.
Yes, Madam.
271.
Your Lordship wanted that whether I have averred that we belong to this category or not.
Let us see. We recorded that you have said that in your writ petition you have averred. Let us see.
Common judgment, my lord, 17/8/2020.
Oh, I am asking a writ petition, sir. What I got?
Paragraph 3.
Where is opposition? Paragraph 3 of the writ petition.
Yes, all the petition.
First. Where is the opposition in this matter? Is there any
Counter affidavit, Mr. Swai?
No.
Was there any counter affidavit filed?
In the writ petition.
Yes.
Nothing was filed.
Or had you filed a common counter affidavit which was adopted? Because it's a judgment passed in batch of writ petitions.
Yes.
17/8/2022. Common judgment passed by the Honorable.
Can you give me the writ petition? Yes. Just 1 minute.
713.
No, which is it? Oh, this one.
So 50 or 100 writ petitions were decided by the division bench. 100.
Yeah, about.
And thereafter writ appeal and only one.
So writ petition can be filed before the single bench?
No, sir, division bench. Thereafter the.
No. It originates from the OA.
Yes.
OA is filed before the Odisha Administrative Tribunal.
Mr.
How the single bench can interfere with this?
Mr. Patel.
Yes, Madam.
What is this order judgment dated 28/2/2019?
19th.
Yes. There, WPC 17, what you are saying, that is there, part of that.
Yes.
Yes.
Which one?
So that this common judgment.
Let me give the background.
Yes, give the background.
We filed OA.
Yes.
That was dismissed.
Dismissed.
Ah.
Then you filed writ petition.
We filed a writ petition.
Yes.
That batch of writ petition.
OA was filed by you.
Yes. We
That is OA 1891
Yes. 1891
was filed by you.
Yes, my lord.
So that was disposed of in view of the earlier.
No, that was disposed of
in view of the earlier judgment
by order dated 20th December 2017.
Correct. On the basis of the earlier judgment passed in another OA.
Correct.
So it was not dismissed.
Yes.
It was disposed of.
Yes, disposed of.
Yes.
There also, the second para, it has been stated, the honorable member has, applicant belonging to SC category who have got diploma in civil engineering and...
No, I am just simply asking, sir. There was a direction was that we hold that the resolution do not confer any right of an indivisible right into the applicant's claiming appointment. Statutory rules, grievance to cause the advertisement and is not allowed, though is not entertainable and maintainable. However, keeping in view of the fact that waiting for a long time, government, a model employee may take a decision as one-time measure and consider the relax.
Correct, my lord.
That's all.
Then we filed the writ petition because on the basis of which this order was passed, that was also challenged. That is writ petition 8877 of 2017. So entire batch of matter decided the issue, and then it was remanded to the tribunal. But we could not see the light of the tribunal because tribunal was abolished. Then again, that writ petition came before my lords.
Yes.
That was decided by honorable single judge, and from there we filed a writ appeal.
Yes.
Sir. Okay. So what is the writ petition you have filed?
Writ petition filed against the...
So what is the number of the writ petition which you have filed? Because I find this writ petition has been disposed of by a division bench.
Disposed of.
By a division bench.
No.
The number you are saying.
One.
The then Chief Justice and the Justice
Mohapatra. No,
order is here.
27130. That is part of this writ petition. Disposed.
28 February 2019. It was disposed of.
Remanded this case to the tribunal.
Yes.
Correct.
Yes.
So this
again I filed a case.
Then, sir, what is the number of that case?
What is the number of the another writ petition?
That number remains the same. I am
no
to say.
If
petition
can't be the same.
No, sir, cannot be.
Many cases I have filed. One case is WPC.
No, not sir. One case where these petitioners were the petitioners.
This number of WPCOSC filed before the tribunal, and the tribunal abolished after abolish.
Yes.
Sir, I understand. What you say is that you, in terms of this order of the division bench, disposing of this writ petition which you are now talking about, 20 something, what you say?
130.
The matter was related back to the tribunal to consider. The tribunal considered, then it is a fresh order of the tribunal.
No.
Sorry, the tribunal did not. Sorry, I stand corrected.
Abolished.
The tribunal did not consider.
So the case
because in the meantime, the matter is transferred to the court in a OA position.
Yes.
Will not this court give a fresh number after the transfer?
Yes.
What is that fresh number?
Each 9 petitioner is not one petition in OA. That 9 petitioner is some petitioner is OA number, WBC OAC number 2975.
Which one is yours, sir? I just wanted to know.
My lord, I have filed 9 petitioners, but 9 petitioners.
But while filing the writ appeal, you filed one.
Yes, one.
Then we are recalling an order and dismissing the writ appeal because of incompetence. The 9 petitioners, the appellants, they filed a respective writ petitions, as he says.
Yes.
and then these respective writ petitions were disposed of by a common judgment.
Yes.
Then you'll have to file a regular appeal against each of the order concerning the writ petition. You cannot segregate some petitioners from other writ petitions, some petitioners from another writ petition, and make them an appellant and challenge the order. Is an incompetent appeal. We are going to dismiss the appeal itself on that score.
Writ appeal.
Yes, writ appeal has to go. It has to go. Cannot be maintained.
Dismiss on the ground of.
We will recall the order and thereafter immediately dismiss the writ appeal on the different ground. That this writ appeal is not competent. The person who were not party to the particular writ petition cannot challenge this.
But they are common from judgment in common manner.
Can you make it?
Your Lordship.
You have filed a different writ petition, separate writ petitions. How can you? It's a writ petitioner who can challenge that order. You are infusing several writ petitioners into one appeal. How can it? Show me the law. I do not know. You have to file a separate one.
Common judgment.
Maybe a common judgment.
But writ
If
petition
50 petitions are disposed of by a common judgment, it should be a 50 appeals that would come.
But it was never raised objection by the court nor by the respondent side.
Sir, cannot court take any time?
They,
The competence of the proceeding is one of the important factors.
My lord,
If the appeal appears to be not maintainable, then what?
my lord, in this writ appeal, my lord, I have challenged 3 writ petitions.
Sir,
Why?
can you do that in one?
Can you? I am asking. Can you? 3 independent or maybe a common judgment, but relatable to each writ petitions.
maybe they may adopt the argument or whatever it is, they have to file several appeals and the court fee also.
They have to. Very unique way of filing an appeal. I am really surprised.
And it was decided also, we were left out belonging to different categories.
Maybe, but it is not a competent. Definitely not a competent. The appeal ultimately has to go.
That is not a fault of client, my lord. It's a fault of advocate, my lord. So that client cannot be suffer.
So because of the fault of the lawyer, the law has to be ignored. The law should be absolutely thrown away. Can it be done? I am just simply asking this. If the law prevents, prohibits, can a court on the ground of default or a fault ignore the proposition of law?
Matter already decided by the division.
It is decided in one way or another, I do not know, but that is what is the competence of the appeal itself. Or at best, it can be maintainable at the behest of the writ petitioner in any of the writ petition.
No, if you confine it to one writ petition, so you select who are the petitioners there.
Then you will have to delete the name of other petitioners.
Yes,
So that exercise you have to do. And that you do not belong to SC/ST, was that the only ground on which the writ appeal has been dismissed?
yes.
That was not the only ground.
Para 11.
That is the additional ground.
Para 11 of the
11,
writ
exactly,
appeal.
para 11.
And the only ground only they are not.
I raised the objection. The government council said no. It was meant for SC/ST, therefore they have no right, indivisible right para 11 of writ appeal.
Mr. Paul, in both ways you
Find out.
either I look in this way or look in this way. In both ways you are out of court. What to do, sir?
My submission, my lord. I have functioned one writ appeal, my writ petition, my lord.
Delete the name of other petitioners.
Yes.
Ready?
Ready. But then I'll fresh liberty to file a fresh.
Liberty to file afresh.
No, no, writ appeal.
A big hurdle of limitation has also already intervened.
My lord, I can assist the court to find out a judgment in which the various writ petition, whatever is decided in one common judgment, then we can file one writ appeal.
Sir, I will correct myself because I know the contrary
That I'm
contrary
saying
judgments,
I will labor for that. That much I can do. Otherwise, this all goes in vain.
It's a very, very, very fundamental first principles of
Correct,
law.
my lord. I admit it first, but there are
first principles of law that a appeal lies either against an order or against a decree.
Yes.
Provided in the statute.
Yes.
The appeal is not an absolute right. It is a statutory right. Unless the statute provides the right of an appeal, you cannot appeal. Very first principle, fundamental principles. And when the appeal is the proper remedy, then there is a procedure or a procedural law which applies. What is the procedural law which regulates the proceeding of the court? Be it a writ petition, be it a civil proceeding, be it what?
I don't know.
It has to be regulated by a procedure.
In our Delhi High Court, there is a section 10, under which we file.
That's under the letter patent.
Yes. Yes.
I came from a court which has a oldest letter patent of 1872 after the mutiny.
Yes.
So their clause 15 also provides for an appeal against the single bench. That's the right of an appeal. But I am talking about the procedure which applies or regulates the proceeding. Two distinct facets. You have, under the latest patent, you can maintain an appeal. There is no doubt about it. That's the right emanating therefrom. But the procedure, who can appeal? A person who is aggrieved by an order, but aggrieved in a proceeding.
I will persuade, don't put
now
in.
Go with the civil side. I am just saying.
Put us into stick jacket. Otherwise, these.
I am giving you an example of a civil. Let us see a civil.
Yes.
There is no bar when there are 10 suits are pending. The court can amalgamate those suits or analogous hearing, and thereafter, by a common judgment, he can dispose of 10 suits. Judgment is common. But since it is a separate suit, 10 degrees will follow.
Correct.
An appeal is against a decree, not against a judgment.
Because in this case also, when the issue was decided, each petition should have gone to the bench and they should have disposed of with the order.
Absolutely. Absolutely. Now, every writ petitioners who felt aggrieved, they could have come up with the separate appeals in that say, and the common judgment, it can be disposed of. There is no difficulty in this regard. But very unique thing which I never heard of, that 3 writ petitioners, they are clubbed together as a category of the appellant and one appeal is filed. This is something which is the first time I have also come to know.
Amendment, my lord, amendment this petition, my lord.
What amendment?
In this writ appeal, my lord.
Question for question. What is this writ petition?
It's my lord, it was
It is
posted for
disposed of.
instruction today.
Disposed of. Huh?
Disposed of last time. That was the direction.
Oh, then it is why the writ petition again.
I is.
What is the IL?
My
What is the
lord,
IL, sir?
IA is for implementing the order of the writ petition.
Yes, what are you doing, sir? Why you are not implementing the order?
The government had to frame a scheme, that was the direction and all that. We have filed this counter only long back saying that is it. Dafayat right will be only given to those persons. Schedule cost, schedule try upper government scheme. So
Which has a lifespan of 5 years.
5 years.
5 years. Now they have
That
already.
is Indian and all that. They have no right.
They
But
continue to continue for more than 2 decades. Then a notice was given to them.
On the Enforcement Act. And this Honorable Court directed that until the scheme is framed, they should not be evicted, they are continuing also.
Correct.
For not, as per the scheme, my lord, they have to only give in a dafade right. Because
But the order is staring at your face. The order is stating you have not challenged this order before the higher forum. Rightly or wrongly, the order is there.
That the scheme is to framed only, my lord.
So why you are not framing any scheme?
Far back in 2019, affidavit was given and all that. What is the development? I have asked for and the chief secretary has already.
Every time when there's a broken bench.
2008, my lord, the chief secretary has also issued guidelines how to go about the matter, and probably that is under consideration. Let it come next week. I will come for it because
no, sir. This was on the last occasion you appeared. Since the matter is of a year 2002, you are unable to diverse the court. Now again the matter is listed. There is nothing.
Only in the point of formation of scheme, my lord.
The court whether any
direction to carry it is regarding the formation of scheme only, man.
Sir, the last occasion when the matter appeared in your presence, you said that is a very old matter.
Oh.
You are not aware of anything. Then in the paragraph 3, we gave you a last chance.
I have to telephone to secretary. No instruction come regarding a scheme.
Then sorry, then we are directing the
agriculture
relevant officer. We are issuing a suo motu contempt. It appears that they have no sanctity to the order.
Let it come next week, my lord.
No, sir. Why every time adjournment, sir?
Because in this case, Kaju Development Corporation is involved, Agriculture Department is involved, Revenue is involved. All they have done, Tahsildar, Block Development Officer, they are all involved, my lord.
All involved, I understand. Then it is whose problem? The order is passed long back, 2022.
And in far back in December 2008, my lord, Chief Secretary has already issued the guideline how to go about in this matter and all that. And as per them, he has said that in the block level there will be formation scheme, and they have to look into this matter for the allotment will made, how the Dafayat right will give in and all that. But after identifying the poorest of the poor persons who are to be benefited under the scheme. My lord. As per that, the scheme is to be made and all.
So when it
Block
will be-
level committee has to look into this matter only and
Well, when we wanted a result, not wanted an explanation. We wanted a result. All this judgment is staring at your face, sir. You have
You-
not challenged the order. You have not sought for a review. Nothing of that kind.
some more time your lordship may give me.
More time. Every time is a more time.
I will talk to the my lord. I will talk to the development commissioner.
Years have gone by, sir.
Yes,
There is
ma'am.
no progress. The order is not challenged. There is no review.
You are still.
So you have to
continuing
comply,
to-
sir.
They are continuing interim order, my lord. They are continuing. But in the last plot, the cashew plantation was there, that was all destroyed. There is nothing there. And
What?
that was for
Nothing
period of
there means?
my
Are
lord.
they not cultivating the cashew nut?
Yes, cultivate. Now, what has been the progress achieved since last order by this
I
court?
have seen.
Well, there is no
Your
affidavit,
lordship,
nothing filed.
it's 2 weeks time and all that. I will talk, see that they will come. Because the guidelines have already been given by the Chief Secretary how to go about in the matter. How the committee is to form, who is the member.
Talking about
2008, my lord. That is the guideline.
25, sir. We are talking about 2020. We are not talking in the year 2025.
Correct, my lord. But the guidelines have set out in the advisory of Chief Secretary, my lord. As per that guideline, they have to proceed.
17 years, more than 17 years have passed. We are now in 26.
2 weeks maybe even, my lord, I will come with it. They are protected, they have been continuing, my lord, with application. Filed in 31/7/29, I had annexed the guidelines that was made by the government also, my lord. That is page 11 in my affidavit dated 31/7/19, filed by the Agriculture Deputy Secretary. This is your, my lord, also.
What is this?
Guidelines of the government to follow.
You are saying the economically stricken persons, for them the policy is adopted to give them a succor to live if they are occupying the land or cultivating the land. But there is no positive result that is coming.
Only that right that is given for 5 years, that is to be renewed, they will give in the the right as per the guidelines, my lord. They cannot, that is the right of usufruct, that is right of a licensee, and they have to use usufructs only. And no land right will be given to them in respect to their land.
Understand then why the court passes an order disposed of the matter, saying that you'll have to adopt a policy for their revival or for their sustenance or for their survival.
So far the petitioner is concerned, your lordship may direct government to take decision in view of this guidelines.
So what is there? The decision has already been done. Now we are in the interlocutory application seeking implementation of the order. Can we modify the order?
No.
Then what we are supposed to do is only
We have to
that
frame the scheme only on Lord. If they will come within the scheme, they have to give in benefit.
it is a solid state of affair that
item number 1.
One, my lord, it is.
Open it.
My lord, in this case, the representation I was directed to disclosure was disclosure long back in 21/9/24, and today I will show the compliance affidavit, and this is the order passed by the AGM disclosure of the.
I have not received
And
any order by
communicated,
her.
ma'am.
Has it been communicated or not?
Yeah.
Communicated. Memo is there, memo number and all that below.
This is memo number. I have not
It
received.
has,
my lord.
your client has not given you a correct instruction.
Because my lord, I have under Annex
That
2.
it has already been communicated to you through a challan.
Memo number 2078.
That whether there is
2078,
memo number,
21/9.
whether that is, I have to obtain instruction because let my senior to serve a copy, my lord. I have instruction because whether they have served on because
What, sir? No, nothing. Where is the order, copy of the order?
One society has made allegation against other society, there are rivalry.
that is different thing. But I haven't
And they are working beyond that.
Annex
by
2 is notice, my lord.
2 inquiry reports are given.
Mr. Kora, please explain what have you decided. Go through that letter and tell us. We are unable to understand anything.
The beautiful English he has written.
My lord,
Beautiful English. Where the, I believe the Nesfield and the Wren and Martin has to be thrown out.
So no reason comes of action is paid for taking action.
What is this? What is the meaning
But
of
the
the word?
Action paid.
today I have filed an affidavit, my lord. Affidavit
I am
compliance.
asking you the English which is used there. Yes, that is what I'm saying. Then Wren and Martin and the Nesfield would have. Is no verb, no adjective, no adverb. Noun becomes verb. Verb becomes noun. I do not know what has happened.
That in English,
That is what I'm saying.
that's what I told. And that was done on basis of 2 inquiry reports, my lord.
Please agree, please tell it.
Give him a copy.
No,
Give him a copy. This
And
is the, this is the abstract of the order. Where is the complete order? Is it a? Where is the complete order?
that was passed in the official file, my lord.
Will you not give a, because it appears that it is an abstract of the order.
Abstract of the order.
Where is
Extract of the order, my lord. I have filed today in my affidavit.
Lago.
I will produce the file, my lord.
no, that is good.
Item number 1.
Please, your lords. Order of this honorable court is already complied with and Plans, Mr. I have filed a complaint affidavit. This is the back to the record, no? Order of appointment complaint that they filed on the last of the. And he has also received against the
I have received yesterday.
We have complied the order. We have given the appointment, sir. Only he has to join. Our part we have come.
Yes.
Now is
Yesterday I have received the order.
because they have handed over today, we cannot able to file the affidavit. We just serve the copy. With passing upon order of the
May it please, Lordship. Item 1, Lordship. It's an application under Section 11.
Where is
Section 11 application, Your Lordship.
where is the arbitration agreement?
Your Lordship, page 16 is of the
Page
page 16, Annexure 1, page 16.
16.
Yes, Lordship. Clause number 24.
Where is the section 21 notice?
34, page 34, Your Lordship. 34, Annexure 5 series.
Where is the receipt?
Your Lordship, page 40.
Yes. Notice.
Obliged, Lordship.
After same matter. No. Returnable requisites by next week.
Obliged, Lordship.
Item number 2.
Item 2, I'm seeking for passover.
But are you not there in the matter?
The conducting counsel will be here shortly. She is accommodated in another court. She will be here shortly.
Next.
Item number 3.
Nobody is there.
Item number 3. Item number 4.
Your Lordship, for the item number 4 and item number 5, I'm seeking an short adjournment on behalf of the petitioner.
4.
Yes, my Lordship, for 4 and item number 5.
Item number 5.
I'm seeking an adjournment for 5 months.
Item number 6.
Much of it.
May I please? I am from VC, madam. Madam, the arbitration agreement is at page 19. Madam. Arbitration clause is page 19.
Where is a attempt for conciliation?
Madam, conciliation is at page, madam, annexure 4, madam.
Page
30.
No, this is true. No, where you attempted to settle your dispute through conciliation.
Madam, I have requested by 28 February 2026 to the special director who is empowered to constitute the DRC conciliation committee to settle disputes. But yes, ma'am.
Where do I get it at page 28?
Well, 28, that is the reply of the executive engineer, madam.
No, where is the conciliation?
That is at page 30, madam. Page 30. 30. Page 30. On 20th February 2026, I have requested.
Yes. Then where is
Thereafter, made a request for a constitutive arbitration tribunal by annexure 5. Page starts from page 37.
Where is the service?
Service matter, that is by register post, and the tracking report is there. 42 and 43. The tracking reports.
Notice 3 weeks.
We are appearing the opposite parts.
What? Then you accept the service?
Yes, we will accept notice.
Then the TSD appears.
My lord. 12 para 12.
Where is the
Page 8.
the notice under section 24, 21?
Annexure 3, my lord. 13/4/26. Delivered on 16/4/2026. Page 14.
Service returnable 3 weeks.
Item number 8.
Service by requisites.
Lordship, the arbitration clause is at page number 46.
46.
Yes. Clause 9.
Forty-six is another mode, not by an arbitration. It is by conciliation.
Lordship, it is as per special conditions of the contract, as per clause 9.2.
Where is that?
Lordship. The special conditions, Your Lordship, are at page starting from page number 47. And the same is at page number 50. Selection of arbitrators. Dispute shall be settled by arbitration in accordance with the following. Page number 50.
50.
Yes, Your Lordship.
Where is a attempt to settle it?
Lordship, page number 80. And a letter for amicable settlement was.
Where is that page?
Page number 80-81.
80-81.
Yes, Your Lordship. Thereafter, there is a series of correspondence.
Oh, this is not a letter for amicable settlement.
Lordship, it is.
Where is the request for amicable settlement?
It's a issue of Your Lordship 30 days notice under GPC clause.
This is relating to a demand. What about that? Now I'm raising a demand. Now dispute has come. I wanted a amicable solution.
Lordship, after that, there has been multiple correspondences in terms of.
Where is that?
Thereafter, Your Lordship, Annexure 15, Annexure 16. From starting from page number 82, there have been discussions, Your Lordship, between the parties. The petitioner has tried, Your Lordship, for multiple times for settlement with the other side.
Service 3 weeks.
Item 9.
Please, Your Lordship. The appointment for sole arbitrator, Your Lordship. Arbitration clause is at clause 32 in page 107, Your Lordship.
My lord, I appear on behalf of the respondent.
What do you say?
My lord, there is no dispute. Whatever disputes were there, which forms a part of the contract, have been discharged. A new no due certificate has also been issued by the respondent, which has been accepted by them. Now, after that, they have invoked the arbitration clause. I mean, they initially wrote a letter.
Where is your letter? Invoking the arbitration, raising a dispute.
It is in.
What is the nature of the dispute?
Dispute is that, Your Lordship.
Show us.
Dispute raised for 47 crores, Your Lordship.
Please show us the letter where.
Letter, Your Lordship. It's in Annexure 8, Your Lordship, page 165.
They have raised, they have claimed the compensation for the default on your part.
Your Lordship.
They themselves in their petition have mentioned that there is a no due certificate which has been issued.
Which one? No dues so far as the supply of the goods or the services are concerned.
No due certificate also in terms of payment that has been made by the party.
That was, Your Lordship, in a one-sided manner, Your Lordship. That was an interim fund they have released.
Where is the statement?
Your Lordship. There has been email correspondence, Your Lordship. In that is attached, Your Lordship.
Page.
Page 159, Your Lordship.
59. Yes.
Your Lordship, they have thereafter in 163, Your Lordship, there has been correspondence, Your Lordship. And it has been admitted that there has been some sort of delay and that it should have been completed within 11 months. Now that has
It's over to 8 years.
8 years, Your
I
Lordship.
understand. I have gone through it. What he's saying is that there was already a no due certificate which was issued, accepted by you. Once you have accepted the no due certificate, there is no question of any dispute alive.
Much.
Your Lordship, because
you have instruction to appear.
I have instructions.
We are directing him to serve the copy of the petition upon you. You file your opposition.
We'll file our opposition.
Let us see. Who will file a wakalatnama?
We have already filed a wakalat.
Oh. No service.
We have been.
Service has been affected or not?
Service has been affected.
Petition is gone.
Yes. We would like. Yes. We would like to file our opposition to it.
Despite
agreement is annexure 2, page 25, and arbitration clause is 13, page 46. Page 46. Clause 13.
Where is the
notice,
raising a dispute?
notice is annexure 13, page 95. 21 notice was issued.
Service.
My lord, they have
Reply.
replied on page 109.
Service 3 weeks.
Item 11.
Correct. You have to kindly come to page number 12. 6. That is the advertising clause. Learning is 12. Contract for construction of building, residential building.
Yes. Then where is the notice under section 21? Where is the notice under section?
Notice, my lord, you will also kindly come to page number 44. That is notice to the advocate that since he avoided to receive the notice, the party I issued a notice to advocate suggesting name of my advocate, but he has not replied to this.
No.
Immediately thereafter, I issued a notice to Honor at page number 19, Annexure 4 series. They suggested a name. I refused because so I suggested one name. He did not receive that notice. Thereafter, I issued a notice to his advocate. He did not respond to that notice. Thereafter, I have come to us.
Service 3 weeks. However, the point relating
the order is at page 226, Lordship.
yes. Then
Lordship, so now as the settlement talks have failed, we are filing this petition in terms of the liberty that has been granted.
What is the claim? Claim of which year?
The claim is of the notice of arbitration is at page 204.
Yes. 204 is the continuation of the application under section 11.6.
Lordship, 196, running page 196, PDF page 204.
Yes. This is of 2022.
Lordship, pursuant to that, Lordship, we had filed the petition. There were talks of settlement going on, and then it was withdrawn.
Then,
Lordship, we are now filing.
In the meantime, now the limitation has intervened, sir. What to
Lordship,
do?
but if your Lordships will please have the order at page 226.
We have seen that was a liberty because you wanted to withdraw. I have seen. You say withdraw with liberty to file, but that must be within the period of limitation. What are you talking about?
No, Lordship, but
maintainable on 22 notice. In 2026, you are filing.
Lordship, but pursuant to that, there were conciliation talks that happened. That talks failed.
Does it stay the operation of the Limitation Act?
The time that is spent in court proceedings, your Lordship, that is excluded. And in terms of
that is excluded under what provision of law, sir?
And Lordship, there were new developments that happened in the case. If your Lordships may please have my arbitration petition.
Where is the case invoking the arbitration? What is the dispute? If a dispute arises prior to 2022, now you are filing in 2026.
No, Lordships, it's a continuing dispute. If your Lordships may please have. Lordships may please have page 10 of the petition.
Recurring cause of action. Show us that what is the recurring cause of action.
Lordships may please have page 10 of the petition.
Yes. What do you say?
Para N, Lordship.
Yes. Yes. Tell me.
Lordships, we had addressed a letter.
Or N or I, which one?
Para N, Lordship.
N.
N.
Yes. Yes.
Lordship, we had addressed a letter in July 2023.
It is what a monetary benefit. You address the letter.
No, Lordship, but if your Lordship may please have para P also.
Yes.
There was an email that was addressed by us because there were certain retrenchment payments that were pending.
Thus, simply issuing the notice for payment or release of the amount extend the period of limitation? I am asking you, sir.
No, it does not, sir. But if your Lordship...
Then in that event, simply because you are writing a letter in 2023, August, July, October, so limitation will run from the day.
Lordships, because there was no specific denial insofar as the claim that we had raised was concerned. So in order to ascertain as to when the limitation period will end.
Let us go that there is no denial of your claim, but there is no acknowledgement of a claim as well. How the limitation will extend, I just wanted to know.
Lordships may then allow me to place the correspondences on record because, your Lordship, there is no specific denial insofar as the claim of our retrenchment is concerned.
Are you aware of the provisions of the Limitation Act? If there is a period of limitation provided in relation to a claim for money,
Lordship,
once the period expires, whether the non-denial extends the period of limitation under section 18 of the Limitation Act, or it is an acknowledgement which would.
Lordships, but if your Lordships may please have the order in terms of which the.
Read section 18 of the Limitation Act. You are arguing something against the spirit of this statutory provision. You have given a notice. Other side did not respond. Anyhow, you can treat it that there is no denial.
Lordship.
Does it wipe out the period of limitation? Tell me.
Lordship, but in terms of the liberty that was granted to us, within 3 years we have come before you.
Liberty does not mean that the period of limitation would go. Provided your dispute must be alive. Your dispute must be legally enforceable dispute.
Lordship, the dispute is very much alive. Lordship, allow me to place the correspondences on record then.
You can place it. For what reason, I do not know. That you want to show me whether there is any acknowledgement by them relating to their liability to pay this amount. If there is, show us, then the second question will come.
Lordship, no. Lordship, may please have page 227, Lordship.
Yes, what it says to us.
Lordship, it is a letter that has been addressed by the other party.
Yes.
In response to our letter, and they have stated that the clause of yes, we have been requested to produce certified documentary evidence of payment of retrenchment benefits. This letter is of November 15, Lordship. Addressed by SAIL to us.
Yes. What? Where is the acknowledgement?
Lordship, they have acknowledged that the issue is live, and that is why we have responded with it. We have responded to this with all the details on the next page, Lordship, page 228. So the dispute is very much alive, Lordship.
That you think, but I am not convinced with that.
But if you Lordship,
alive, I am not very much convinced.
Lordships, if you may please have page 227, bottom line.
I have seen that this will be reimbursed as per clause 23.5. I have read it. You are requested to comply 23.5. I understood.
So they are acknowledging, Lordship. That is my submission.
No acknowledgement. There is no acknowledgement.
Lordship, this is the acknowledgement, and that is why we've been.
Please read section 18 of the limitation. They have the copy of the Limitation Act.
Not true.
Read that.
Effect of acknowledgement in writing.
Yes.
Where before the expiration of the prescribed period for a suit or application.
What is the very most important thing?
Before the expiry of the prescribed limitation.
Yes. Then read.
In respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing signed by the party against whom such property or right is claimed, or by any person through whom he derives his title or liability. A fresh period of limitation shall be computed from the time when the acknowledgement was so signed.
True.
Where the writing.
That will gives you, there are three, the important facets. One is that acknowledgement must be within the period of limitation, not beyond the period of limitation. If the relief is barred by limitation, that acknowledgement will not have that. Second thing is the liability must be admitted or acknowledged.
Lordship.
That means when you say the quantification, that quantification must have been acknowledged.
Lordship. So, Lordship, if in my understanding, Lordship, in that
they may acknowledge, yes, I admit 40 crores, or they may say, I admit 20 crores.
Lordships, but in my submission, Lordships, the letter that they have issued on November 2023.
Not say that you have not complied this order, we are not.
No, Lordship, that is an
Please, the Limitation Act does not destroy your right.
Lordship.
What it prevents or bars the relief from the court.
Lordship.
Nothing. Your right may still be there, but you cannot seek you have approached the court for a relief. Whether the relief can be granted by the court.
Lordship.
You may have a right. I don't dispute. That right is the right does not evaporate, but your relief from the court evaporates.
Lordship, but in my submission.
Do not know. Do not know, sir.
Lordship, in my submission, because this letter acknowledges to the limited extent that I
will say, I will interpret that whether it amounts to an acknowledgement under section 18.
Lordship may allow me to address on this. Lordship, I'll address it physically. Your Lordship allows. Lordship.
When?
Lordship may fix a short date whenever Lordship deems convenient.
How short?
The 2nd of September. 2nd of September.
This is a short date. Second. Come ready, sir.
Lordship.
13.
Your Lordship, I beg your apology for appearing online in this item. In item number 13, I'm appearing for the petitioner, Your Lordship. Your Lordship, the agreement in question, the arbitration clause, is at Annexure 1 at page number 33, clause 13.7, subclause 2, Your Lordship. Page 33, clause 13.7. Subclause 2, Your Lordship. If I may read, Your Lordship, for your convenience.
I'm a faster reader than you.
I apologize, Your Lordship. Your Lordship, demand.
Where is your attempt for conciliation?
Your Lordship, my attempt for conciliation is, Your Lordship, at annexure A5, page number, annexure 5, page number 144, Your Lordship.
Page number?
Page number 144, annexure 5, Your Lordship. Letter dated 23rd February 2026, Your Lordship. We attempted to reconciliate, and after its failure, Your Lordship, at annexure 7 at 140. I beg your pardon, Your Lordship.
1 minute, have a patience.
I beg your pardon. I beg your pardon, Your Lordship.
Can you show me any correspondences prior to this notice which you are
Your Lordship.
that before any correspondences? I have read paragraph 17 and 18. You wanted to highlight them.
Your Lordship.
Don't worry, but I just wanted any previous correspondences.
Your
In
Lordship,
support of paragraph 17.
Your Lordship, first our demand was raised at Annexure 2 at page number 130. That is our first demand in pursuance to that particular the agreement, Your Lordship.
No, I just wanted that whether there is an attempt on the part of on your part to have it negotiated through
Your
the
Lordship,
settlement.
Your Lordship, that particular notice was aimed at under section the clause 13(1) for dispute resolution through conciliation, Your Lordship. The arbitration came thereafter, Your Lordship. This Annexure 5 notice, Your Lordship.
So that is you have paragraph 17, you say, I attempted for amicable solution or resolution, but it has failed. I just wanted to say, where is your attempt for? But these are now a very unique arbitration clauses, which we call it a mid-arm.
Your Lordship.
It is really a mid-arm. First, you show that you have complied mid, then arm.
Your Lordship. Your Lordship, actually, the attempts to negotiation, the factual facts as such, we first raised our demand under Annexure 2 in May 2025. Thereafter, on 28 at Annexure 3 at page 134, on 28th May, the other side responded and they terminated the agreement.
Yes.
After its termination, we have sent this particular notice under Annexure 5, Your Lordship. At paragraph 17, Your Lordship highlighted. At paragraph 19 of this notice, we have actually clarified that we, the attorney, that is us, the petitioner, remains committed to resolving the dispute between the parties through amicable means, through mutual consultations and negotiations in compliance with under clause 13, subclause 7, subclause 1, Your Lordship, thereby complying with the terms of the agreement.
Notice, very interesting composite notice.
Your Lordship, it is not a composite notice because even though
obviously you say that I am giving you a notice. If the negotiation fails within 30 days, it will be treated as a notice for arbitration.
Your Lordship, despite the language, Your Lordship, we have actually sent a separate, distinct arbitration notice, which is at Annexure 7, Your Lordship.
Where is that separate, distinct notice?
Annexure 7, Your Lordship, at page 153.
Yes. Notice.
Much obliged, Your Lordship.
Item number 14.
Like that.
3 weeks.
There was a construction agreement, and in that agreement, on agreement arbitration clause, page number 30.
What is this agreement?
This is a contract for construction of a building at Puri, Millers. Construction of building at Puri.
So what agreement?
Agreement start as page number 10, Millers, Annexure 1. They have entered into a contract.
Is a development agreement?
Mile, development agreement.
Are you having a share?
Yes.
Huh?
Yes.
Is it not compulsorily registrable or a stamp duty will be attracted?
No. It is a notarized development agreement.
Does it not attract the stamp duty to be leviable thereupon?
Done in
development agreement, creating an interest in the involved property.
Yes.
Does it not attract
the one agreement? This was notarized agreement. Thereafter, registered power of attorney was executed in his favor. Registered power of attorney was executed in his favor to do the work. So he failed to work.
Can a property be transferred through a registered power of attorney?
No.
It should be transferred by a valid transfer deed. Now, question is that once a right is created, does it invite any stamp duty to be leviable thereupon? I'm not talking about registry.
No.
Yes. Then will I take it in section 11
Lordship,
unless it is impounded.
only impounded, thereafter I have to pay court fee on the same. Well,
That's what I'm saying. Then I have to take recourse to section 33.
What has happened? I went to
of the
civil court.
Stamp Act,
I went to civil court. Civil court referred the matter to arbitration.
section 8.
Yes.
Maybe, but still in section 8 I am grappled with
Assam Tea House case, you also must have come
5,
across.
7 judges bench. Right from NN Global to Interplay. What can I do?
With Assam Tea House case. That case
Assam Tea is not recent. I'm talking about the stamp duty.
Yes. That court has to import the same. I have to pay the court fee and thereafter it is.
So that's why I'm asking whether it invites a stamp duty.
No,
Yeah, in the state of Odisha, I'm asking you.
Yeah, I think he should check it up. I don't think
Developers agreement.
it is
No,
not.
in some of the state it is.
Yes.
It's
Not
like
here.
a agreement for sale.
Sale is compulsory.
That's why it's creating an interest in the immune
No, it is
property
not.
more than 100 rupees.
Yes.
I'm just asking what is the Odisha Stamp Act? Any amendment in the Stamp Act? So far as Odisha is concerned. This is a hybrid kind of an agreement.
Development agreement. I'll check it out. Next.
What is that? Gulati's judgment of the Supreme Court? That first name? Fakir Chand Gulati. F-A-Q-I-R, not K-I-R. Of Justice Ravindran, if I am not wrong. The nature of these agreements have been vividly discussed about it. And then how a right is created under it. Go through this.
Item 15.
What, next week or 2 weeks?
Next week, I'll check it out.
Item 15.
The arbitration clause is at page number 124, Annex 1. Arbitration clause is at page number 124, 126 minutes. Demand for arbitration.
126
minutes.
Yes.
Notice
What is the nature? Is the contractual one?
Yes, ma'am.
For doing some civil work?
Yes, my lord, civil. Unpaid dues, my lord, and security deposit. Security deposit they have forfeited and unpaid dues.
Now, that where you have raised issue.
My lord, so that is at Annex 2.
What is the dispute?
Annex 2, we have raised the section 21 notices at Annex 2, my lord. Page number 131.
Any response to this letter?
Yes, my lords. Annex 3 is the response. They are seeking waiver of section 12(5). Annex 3, page 136.
Yes. Constitution. So you have not agreed.
No, my lords.
They wanted to keep it within their domain. So you have not agreed. No waiver. Yes.
Take notice. Accept notice for opposite parties 1 and 2.
Order that Mr. Kashyap appears and waives service of notice of the and prays for a direction upon the petition.
Day
By Monday. Uh, weeks.
Item 16.
Therefore, it is support.
A filing machine, and they've used it here in Odisha, and there's some amount they paid. Lastly, they didn't pay.
Where is the demand?
Page 35. Invoke the arbitration clause and also name the arbitrator.
But they did not agree.
No. They never responded also. Agreeing is fine part.
Service 3 weeks.
Item number 17.
May it please your lordship. Petitioner prays to revoke arbitration clause on the ground of section 3G, 5 and 6 of the NHA Act. My lords, a land was acquired by the NHA Act section 3G.
Give me. How is that?
5 and 6, my lords.
What is nexus between subsection 5 and subsection 6 or 3G?
My lords, if the amount of compensation.
No, just I was saying, if the appointing authority is provided therein, then what about subsection 6?
My lords, as far as my understanding is concerned, both has to go in hand, because
No, because subsection 6 start with the language subject to. the provision of this act means an overriding effect. So does it not mean it is only the procedural part of the Arbitration and Conciliation Act which will apply, not substantive? I'm just thinking aloud.
Well, if I may be permitted, what happened? My understanding after reading a bit, which came to my institute is, basically, if we see Arbitration and Conciliation Act, the arbitrator is appointed basing upon the agreement. Both the parties agree what are the terms and conditions, and if terms and conditions are violated, and if there is a clause for appointment of the arbitrator, then 11 comes into the picture. But here, Muller's NHA Act is in this
It's a special act. Then tell me, is also central legislation.
Yes.
No difficulty.
Yes.
Then,
Muller's in this supposedly the quantum of compensation. In this case, my land has been acquired.
I'm simply asking so far as the power to appoint an arbitrator is concerned. I have seen this subsection 5. It says that in case of the determination will be done by an authority. If either of the parties are not agreeing on the compensation so determined, then the compensation shall be determined by the arbitrator appointed by the competent authority.
Central government.
That is what is there. 6 says, subject to the provision of this act, the provisions of the Arbitration and Conciliation Act will apply.
Yes, Mullah.
Now, what is the nexus? So how we have to understand it?
Mullah,
Section 11 confers power upon the High Court to appoint the arbitrator, whereas it says no, it will be appointed by a competent authority. First, now, when there is a conflict between the Arbitration Act and the provision of the NHAI, who should be the appointing authority for an arbitrator? Then, in my view, what is the law which would apply? Can the High Court appoint an arbitrator? I'm asking under Section 11.
Muller's initially the obligation is vested upon the central government's appropriate officer. But if central government's appropriate officer is failing or is not working according to the statutory requirement, then it is obviously the Honorable High Court.
Where is a refusal on their part to appoint an arbitrator?
Mullers, there is implied refusal. Mullers may see, I have repeated.
It's an interesting point. I will definitely go in. You have not worked on that. Anyhow.
Mullers, I'll go through and find out the judgment.
Come with the what is the meaning of the expression subject to the provision of this act?
Grateful. I'll be grateful.
Service returnable 3 weeks. The point of
wanted to mind to withdraw man.
We request a date to exchange.
18th. 18th.
My lord, because my lord, order has been already passed in court below.
Anyhow, please for withdraw. Give what is required here. Memo has to be given. Yeah.
Item number 19.
Please, Your Lordship, I'm appearing on behalf of the applicant. This is a section 11. The arbitration clause, Your Lordship, is at page 24. Page 24 is the arbitration clause. Clause 8.1.
Yes.
My notice invoking arbitration, Your Lordship, is at page 26.
What is the nature?
This is a slum redevelopment project. Page 15, Your Lordship, is my contract.
Is the only construction contractors agreement?
Yes. I was a contractor.
Invocation?
Invocation at page 26, Your Lordship. My claims are at page 28.
Yeah. Notice has been given.
Notice has not been issued, Your Lordship.
3 weeks. Notice.
Much obliged.
Item number 20.
May I please? But in this case,
where is the?
Here, he's
I'm online, Your Lordship.
both the parties have already filed our written notes of submissions and the judgments which are in record.
Where is that? What is this judgment? Who has filed?
I have also filed my written submission, Lordship.
Submitted by, yes, is submitted by you. You are for the petitioner or who?
I am for the petitioner.
You are for the petitioner.
Yes.
Why you are standing on a wrong side?
The other side.
These two judgments you are fighting. You are filing.
I am filing 5 judgments.
Sanchar, you are citing. I find.
I am citing
India Limited.
I am citing Hawaii Technologies, Yashvit Construction, Khorshed Nagarwala, and Sailesh Dharian.
5 and these two. What is this?
I have not filed.
What are you? Your name is reflected at the top. Huh? Because your name is at the top and written.
May ignore this too.
Yes, your name is reflected.
Yeah, my name is reflected.
So
I have given my judgments with the notes of submission compiled. And I think this is that 30 days limitation. If he doesn't reply to my notice, then the right to appoint or suggest a name extinguishes.
Is he citing?
He is also citing one judgment which
what is the dispute? Can you refresh?
This is, my lord, this appointment of a substituted arbitrator.
Okay.
Because there were 3 arbitrators appointed. The presiding arbitrator, the third arbitrator was appointed by the Honorable Supreme Court. Now, arbitration proceeding was on. There was a dispute order where I was aggrieved. I filed a writ application in the High Court and the proceeding was stayed. Wrongly or rightly, I filed a writ application, the proceeding was stayed. Thereafter, after 10 years, my lords, in the meantime, both the arbitrators had passed away. Senior judges, retired judges of the High Court passed away. So, my lords, in the High Court, I said that I want to withdraw this writ application now because the arbitration proceeding arbitrators have led. And I took a liberty from the High Court that I will issue fresh notice for appointment. And accordingly, liberty was granted by the Honorable High Court. Thereafter, I issued a notice to them suggesting that I have appointed retired Justice Bhanumati as our arbitrator. Please suggest your arbitrator. They kept quiet. They did not reply. Then we wrote a letter to the surviving arbitrator. He also did not reply. Then I filed this 11-6.
What is the law on the subject?
Law of the subject is your lordship will exercise power under 11-6 to appoint because he has refused, and now under clause 11-5, since he did not reply within 30 days, so he is the right.
What is his defense, sir? What is your defense?
Your Lordship, my defense is that this 11-6 application is res judicata and it's not at all maintainable.
Res judicata?
Yes, Your Lordship. He has to invoke section 15 if I may read out section 14, that which is say the failure or impossibility to act. The mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if he becomes de jure or de facto unable to perform his functions or for other reasons fails to act without undue delay. So, Lordship, I am submitting this 11.6 is res judicata, is not at all maintainable, and he should have approached this Honorable Court through section 15 by filing an application under section 15, where it says the termination of mandate and substitution of arbitrator. And the Lordship, in between the stay which has been granted by this Honorable Court in writ petition 20900 of 2012, they sat upon the stay, even if they having the knowledge that Asian's resurfacing judgment had come into effect in 2018, where it says if it is the stay is if it is beyond 6 months or more, then the stay will be automatically vacated. I want to the Asian resurfacing, Your Lordship, in 2018. 16 SEC 299, Your Lordship.
2018 volume?
Volume 16 SEC page number 1 second, Your Lordship. One second, sorry.
Volume 16.
Set aside.
It was set aside in 2024. 2018 16 SEC 299. It was ultimately subsided by 2024 judgment. But by the time 2024 judgment came, he had already filed this 11.6.
I was really surprised because that's why I showed my keenness in reading the judgment. That's why I wanted.
Lordship,
is overruled 2024 with judgment.
That was Justice Chandrachud, if I may recollect, Your Lordship. But what I wanted to submit through this judgment, Your Lordship, the judgment was in effect till 2024, where it was overruled.
Judgment now. Have you read the recent judgment of the Supreme Court that whenever pronouncement is made, it will have a retrospective effect unless the court says that the judgment will operate prospectively.
But by the time the petitioner was already before this Honorable Court.
And a retrospective operation we have to consider. Anyhow, I will go through it. Contention is that once the mandate of the arbitration is terminated, then in that event they cannot come under section 11. They can at least come under section 15, not.
Please, Lordship, I have submitted two judgments.
Yashwit Construction?
Yes, Your Lordship.
That is Dharewan.
Yes, Shailesh Dharewan versus Mohan Balkrishnan Lula.
Yes, what you are two judgments you are relying on.
Lordship.
Have a privilege of this copy of the judgments because
I have also relied on and those are in the record.
You have?
Yes.
Yes, Shailesh we have relied on.
Yashwat also.
And Yashwat also. Okay. Yes, we have the copy. Yes, keep it for next week for orders in the court. Because the parties conclude. Sir, you are not understanding what I am saying. That you have filed your written notes of argument. That is why I was saying that you are relying on these two judgments. How do I know that you are relying on these two judgments? It is only from your written notes of argument.
Lordship, I'll supply the judgments by Monday, Lordship.
No, I got. He has actually given a compilation of 5 judgments, which includes these 2 judgments as well.
No, Lordship, he has not Sailesh Dharavan versus
Yashwit and Dharavan.
Yes.
I think serial number 2 and 5, if I correctly remember.
Absolutely.
Please, Lordship. Please, Lordship.
Your Lordship's reading is much more faster than any of us. Oh, next.
Which one?
Item 2. Item number 2. Past one.
Yes.
Your Lordship, I appear on behalf of the petitioner. The arbitration clause, the arbitration agreement is at Annexure A1.
Why it is Passover? They were not there. Oh, senior was not there. So, yes.
Your Lordship, the arbitration agreement is at page 30 of Annexure A1. Clause 25.
Yes. Yes.
And Your Lordship, the petitioner has sent the respondent a letter, notice invoking arbitration, which is at Annexure A7, page 61.
Is it an enforceable contract?
Your Lordship, it is stamped and it is an employment contract.
Is it enforceable in eye of law?
Yes, Your Lordship.
How? Under what provision of the Specific Relief Act?
Your Lordship,
It is absolutely a personal contract, personal service contract.
Your Lordship, it is a breach of contract. And
That's why I'm saying, madam, if there is breach of contract, then it has to be remedied. You can seek for certain enforcement of the contract. If the law does not permit the enforcement of such a contract, can you sue an arbitration because they are enforcing the contract?
Your Lordship, we are enforcing the contract and
No, give me a specific relief act. It's a personal contract. Specific relief act.
Your Lordship, I am claiming damages.
That's the only right you can claim.
Yes,
Nothing more than that.
Yes, Your Lordship.
I find that you are claiming many things more.
Your Lordship.
Many things more. You are claiming that termination is bad, all declaration, everything you are now.
Your Lordship, this is a case where the employee has abandoned duties without following the contractual terms.
Whatever.
The petitioner has suffered losses.
Who are you, employer?
I am the employer, Your Lordship.
Can you ask even a preventive order under section 45? 42.
Your Lordship, I am not seeking specific performance, Your Lordship. My entire claim is that there has been a breach by the employee. I am suing for damages. There is an arbitration agreement in place. I have
where you are suing, where you have quantified the damages.
Your Lordship, I have not quantified the
damages. How can you? It's a liquidated damages. One has to. Then.
Your Lordship, there is not.
Because I have gone through your letter invoking an
Lordship.
arbitration.
Yes,
Anything you have asked for, except this.
Your Lordship, all.
You could have claimed that you have suffered the damages of this nature.
I have, Your Lordship.
Where you have not said. I have seen page 54, sir. Madam, I have there,
Your Lordship, if
paragraph 15.
if you look at page 53, para 11.
Yes. How much you have?
I have, Your Lordship, I have not quantified.
That is what I'm saying. Page 54 also come to paragraph 15.
Yes, Your Lordship.
That is what you're saying.
Your Lordship, I agree.
Come ready on this score. I can't.
Okay, Your Lordship.
Otherwise, you'll have to amend it. Take further recourse.
Obliged, Your Lordship.
Whether this notice would be there or not. Yes. 2 weeks. How much time?
Your Lordship, 4 weeks, please. 4 weeks, please.
Oh, 4 weeks.
Or Your Lordship, I leave it to you.
No, 4 weeks.
Item number 3.
May I please? May I please, Your Lordship?
Yeah.
My Lord, may I take Your Lordship to page 34, which is the arbitration clause. 34, para 9. If any dispute or difference arises out of this agreement or in connection connection with the execution.
Yes. Where is the notice? What is the nature of the contract?
Share purchase agreement, my Lord.
Share purchase. What is the?
My Lord, first my demand notice is at page 44, and then the arbitration notice at 69. And it has been duly delivered. I have annexed the tracking report. Obliged. May I pray for a date?
They will give you.
Obliged.